We're happy to welcome Jim Dodrill this evening. He is an attorney from Boca Raton, Florida. He specializes in corporate securities and transactional law. His firm offers expert guidance to navigate compliance with the Corporate Transparency Act, and he's here to help us figure out what we're supposed to do. So, Jim, take it away.
Sure, great. Thanks, Lorna, and I really appreciate being here tonight to speak with everybody. So it's a very important act that we need to talk about and something that everybody should know. So we'll just dive into it here quickly. You gave the introduction there, so I won't jump through much of it here. But yeah, I've been practicing law for over 30 years, and always in the corporate and securities transaction space. And the last 24 plus have been as a solo practitioner and have a global client base, companies coast to coast in the United States as well as around the world that I assist in various ways. So first, a quick disclaimer. I am an attorney, but obviously I've not been retained by anyone on this. So the information we're going to go through this evening is just for informational purposes. It does not constitute and is not legal advice. So it's not a substitute for professional advice either. So anyone who is affected by this, by this act, obviously can certainly reach out to me or your own professional, but you should seek real professional advice on it. So that's about that. So let's move on. So first things first, what is the Corporate Transparency Act? Um, it's a new federal act that just went into place at the beginning of this year, on January 1st of this year, and it was passed back in 2021, really as kind of an outgrowth of issues relating to 9/11. It's basically the government's attempts, or one of their attempts, to solve various problems that they learned from that, and to try to determine ways in which funds are being transferred, who's transferring them, and who's controlling various parties here in the United States. So, and there was kind of an evolution along this. I mean, it really started with the Patriot Act when that came out, which put certain obligations on banks and other institutions to collect certain information about their customers, the KYC, or Know Your Customer obligations. You may be familiar with that. There are efforts actually in the legal profession. In the Senate, was proposed legislation that was going to require that attorneys effectively, turn their clients in if they learned of certain activities were being taken place. It ultimately wasn't passed, but that was bandied about as well. And then ultimately on January 1st of 2021, as part of the National Defense Authorization Act, this was passed. And it's important to know that this was passed over presidential veto, and it was a bipartisan effort. There was very broad support for it within both houses of Congress to get this done. So what is it meant to do? What's the mandate of it? So the act requires that the FinCEN, Financial Crimes Enforcement Network, which is a division of the Treasury Department, create a national database that maintains information about the beneficial owners of entities here in the United States. And we'll get into a lot of what we're going to talk about today it revolves around definitions and what they mean for who has to comply and what they have to do. But it's requiring that information about beneficial owners and entities be submitted and maintained by FinCEN. And the purpose of this is to help prevent funding of terrorism, money laundering, essentially anyone who's trying to hide funds and or assets, from the government, and putting, obligations in place for them to make these disclosures. Some of you may have heard or seen headlines, on social media or newspapers, whatever, about various challenges that have started to this act. The sound bites in the media are really misleading. If we were having this talk, 3 or 4 months ago, there was in April, a U.S. District Court in Louisiana came out and declared the act unconstitutional. That was the headline. But in reality, the decision that came out, specifically stated that it only applied to the plaintiffs in that case and had no application to anyone outside of it. And since that point, that's still in place and working its way kind of up through the court systems. In a different district court, the act was challenged, and the court in that district came out and said, no, this is completely valid, congressional act, complies with the Constitution. There are no issues. So there are different items out there. The Treasury Department did come out after the first opinion and stated, and it's still on their website, that while the first lawsuit is working its way through the courts, they will not enforce the legislation against those plaintiffs only, but that for everyone else, it's still game on, and everyone else is still expected to comply in all ways with the act. So some of you may have heard at some point something saying, "Oh no, the act was found to be unconstitutional." In an extremely limited circumstance, and the plaintiff pool in that literally is a very small fraction of 1% of the entities that need to comply. So the odds are that nobody on this call is ever going to meet someone who actually was part of that plaintiff group. So. I should say also, as we're going through this, if anyone does have questions, feel free to raise your digital hand, and I'm sure Janine can, if I don't say it quickly, but she can call it out, and we can try and address those. Obviously, if it's getting too much in the weeds for any specific individual circumstance, it may make sense to have the conversations offline at a later point. But I'll try to address the questions as we go through this. So we talked about the fact that this has put in place a reporting obligation. So what is that? So the reporting obligation is for reporting companies, and as you see, I have that in quotation marks because that's a defined term within the statute that we'll get into exactly what that means here in a minute. But for reporting companies, they're required to report as follows. Any entity that's subject to this act that existed prior to January 1st of this year must file their initial report by January 1st of 2025. So, approximately 10 weeks from now, which is why this is particularly important right now, because the deadline for compliance is rapidly approaching. For any entities that are formed during the calendar year 2024, they have a total of 90 calendar days after receiving notice of the creation of their entity to file. And that's after receiving actual notice or constructive notice, public notice. So many of you may know that, for example, if you form a limited liability company in your state, that you'll send, a document goes to the Secretary of State for that purpose. The Secretary of State may publish something on its website showing that that your entity, I'll pick on Matt since I know him, that, Matt Wilson LLC was formed on October 1st of this year. And they have that on their website now. And even if, Matt didn't receive an actual letter from the Secretary of State, or even if he doesn't ever go on and check their website, that's still deemed to be notice to him of it being formed, which starts the clock ticking for compliance. An extremely important fact to remember is that starting this coming January 1st, that 90-day period shrinks down to 30 calendar days. So it's going to be extremely important for entities to act very rapidly when any sort of new business is formed, and because, as we'll see, for effectively all new entities as they're formed, it's really going to be virtually impossible for them to avoid the obligation of filing. So what information is reported? So the information falls into two categories. So it's information about the entity itself, and then information about the individuals with direct or indirect control of the entity. So for the entity, the information is the name of the entity, any trade, fictitious name, DBA, different states refer to it different ways, but anything like that is used for the entity. Importantly, even if that's informal, even if you've not filed the proper paperwork for a DBA, you still, if it's something you use as part of this entity, you still have the obligation of including that. Excuse me. The entity's EIN must be reported. The jurisdiction of formation. What state, or it could be a Native American Indian tribe. Isn't always a state, but the majority of the time will be the state that it's formed. The physical address of the entity, no PO boxes, mailing, mailbox addresses, UPS type stores, anything like that. Uh, as well as for any new entity, anything formed from January 1st of this year on, the company applicant. And again, I'll get into what that means in just a little bit. But all that information must be filed for the entity. For the beneficial owner, and we'll get into this because the beneficial owner really is a misnomer, because when you hear beneficial owner, you're thinking about people who own something, right? But it's not just owners, as we'll explore here soon. But for anyone who meets the definition of a beneficial owner, it's their name, their date of birth, their residential address, and then some sort of unique identifying number, be that their driver's license number, passport number, or something like that. It has to be from a valid either U.S. driver's license or a valid passport from any country. And then whatever you're using for that identifying number, you actually also have to submit a copy of that ID as well. So definitions, kind of again getting into probably what most of you will hopefully find the most informative part of this presentation. What is a reporting company? As you'll see as we go through this, these definitions are very broad. They are meant to capture as many groups as possible. For a reporting company, it's again, there are two types of them. There's domestic reporting companies, which are entities formed in the United States, and then there's foreign for outside the US. But for domestic reporting companies, it's corporations, limited liability companies, and this is kind of where your catch-all comes in. Any other entity created by the filing of a document with a Secretary of State or any similar office in the United States. Very broad reaching. So, and again, state, includes U.S. territories, Puerto Rico, for example, whatever is, and would capture, anything within a tribal entity as well. So again, effectively anything created by filing any document with a governmental agency is caught within that. And this would be for the domestic side. For if an entity was formed somewhere in Europe, for example, they obviously don't fall within that definition. But for any foreign entity, if it has filed any document in any of these jurisdictions to do business in the United States or otherwise registered in the United States to do business, again, by filing any document with any of these types of entities, then it too is captured for this. So again, very, very, broad definition for that.
Jim,
Yes.
I think Assam had a question.
Oh, sure. Sorry, I didn't.
Yes, Jim, I mean, are we going to have these slides or should we be taking notes?
The slides will be available for you. Yes.
Okay, thank you.
Yes. Yeah. The presentation. Janine has a copy of that, and she'll be happy to distribute that. If you
Yeah.
want a copy afterwards.
Okay, thanks. Okay.
So there are exemptions to this, even if you are caught within those definitions. There are 23 exemptions from registration, or from being required to file. Obviously, we don't have the time to run through all of those exemptions and the nuances for them, but effectively they fall into a few groups. There's the regulated entity group, which is public companies. It is banks. It is registered broker dealers. It is public company accounting offices. And then there's also what I would call the big three, if you will, which is entities that have a tax exemption, 501c exemption, okay? Large operating entities, and I'll kind of dig into each of these in a little bit more in a minute, large operating entities or inactive entities, because some people say, oh, I have this, LLC I've created and I don't do anything with it, so do I have to file? So for the charitable entities, they have to actually have had their 501c papers issued by the IRS. And as I was saying, for any new entity going forward, the odds of that happening within 30 days of when an entity is formed is probably fairly slim. So in all likelihood, entities will have to file, and then if they meet an exemption later, they file a second time. They file an updated report showing that they're no longer subject to the filings. For the large operating entities, that's a large operating entity is defined as an entity that has all of the following. They must have 21 or more full-time employees. So, consultants, contractors don't count, and it's full-time. They have to be, on the payroll, minimum 30 hours a week effectively, or I think the number is like 130 for the month, but full-time employees. They also must have a physical presence, physical, operating office where they're operating from, that cannot be a shared space with any unaffiliated entities. So if they're setting up their office in a like an executive suite situation, that would not meet this, even if they're doing, even if they've taken most of the executive suite and they have 30 people, 50 people, 100 people right there working as employees, but if shared also with other people who are not part of that, they would not meet that requirement. They also must have reported on their most recent tax return a minimum of $5 million in gross domestic revenue. So they have to meet all of those in order to meet that exemption. If there's a point, even if an entity meets them at one point, if they drop below those numbers, okay, they've had some layoffs, they had a bad year and their revenue went down, whatever, anything along those lines to where they don't meet all of those requirements on an ongoing basis, whenever they do drop below it, they now are subject to file their reports at that time, and they would have at that point 30 days to file the updated report showing that they are indeed doing it. Last of these, the so-called big three that I refer to is the inactive entities. And an inactive entity for these purposes doesn't mean some LLC that you've created that holds property to a title to some property that you own. In order to be an inactive entity for these purposes, the entity has a laundry list of things that must meet all of them. It must have been formed prior to January 1st of 2020. It must have no active business operations, no foreign ownership, so only owned by U.S. citizens, no change in ownership in the last 12 months, no transactions in the aggregate of $1,000 in the last 12 months, incoming or outgoing, and importantly, no other assets. So an entity that is simply owns title to property would not be an inactive entity for this. If you've created a holding company structure where you have one entity that simply holds your stock in another company, that is not an inactive entity. It would not meet these requirements, and it would be subject to reporting for all of these. So, an important thing to remember also is I'm talking about the large operating entity. I should have mentioned this. I'm sorry, but even if an entity in its first year of operations opens up and they've hired a significant number of people and they have their physical plant, they can't meet the requirement of having filed a tax return showing $5 million in revenue. So since the obligation is to file for any new entity within 90 days now or 30 days going forward to file, every new entity effectively is going to need to file at the onset, again, unless in some capacity they meet the definition or one of these regulated industries, but otherwise they're going to need to file and then file when and if they do become exempt from filing. So so it's just something to remember for anything new that you create. So yes. So is that you're raising your hand, Muse?
Yes.
You're on mute. So
Okay, I just unmuted. Is there a standard form for reporting this information? Is there a standard form for reporting?
and short answer is no. I mean, we'll get into it because again, there are, and we'll get into kind of how the services associated with this work.
Okay.
But in all entities, there are questions we'll get into. One of the big things that's coming up right now, I'm about to jump into, which is who are the beneficial owners for these entities. And again, as part of that, there's a level of legal analysis that goes into determining who needs to be named in all of these circumstances. Sometimes it's clear cut, a lot of times it's not though. And on the beneficial owner, as I'm saying, it's really a misnomer because it's not just the owners, it's owners and or people who have substantial control. It's dealing with direct or indirect. So on the ownership side of it, anyone who has direct or indirect ownership of 25% or more of an entity, okay, is deemed to be a beneficial owner. And interestingly, the way it's calculated, there can actually be more than 4 owners of 25%. For example, if someone lives in a community property state, the ownership is imputed to both spouses. So if you had 4 couples that each own 25% of an entity, you have 8 individuals who own 25% or more of the business. Also, contingent or convertible securities play for that as well. So if you have someone who has for example, options to acquire a certain amount of equity in a company, or they have convertible debt that can convert into a certain amount of ownership. Depending upon what that does for increasing their position, their ownership position, even if they don't own any stock, for lack of a better word right now, today they could still be deemed the owner of 25% or more of the entity. And each person is calculated separately. So again, you could have the 8 people I just spoke of who have 25% or more because of the community property. And then let's say for some reason I've been given an option to acquire 25% of the business from the business itself. I now have to be reported as well, even though if I exercised all of the pre-existing owners, the owners right now, they would be diluted. So they wouldn't continue to have 25%, they would have less. But the act captures all of those people and requires all of them to report. It also captures anyone who has control, indirect or direct, substantial control, and who is an important decision maker. So this includes C-level executives of entities, boards of directors. If you've given veto rights as part of a finance transaction to a financing party, they potentially, depending upon what the terms are, could be deemed to be an important decision maker and have to be listed. And again, there's a catch-all as part of this where that states for any other form of decision-making power with this. So again, it captures many people with this. Similarly, ownership interests. Even if the ownership interest doesn't have voting rights associated with it. So I think I mentioned a minute ago if someone has convertible debt, or they have an option presently, or they have non-voting stock, non-voting membership interest in an LLC, and all of these, whether even if they have no input from a managerial standpoint, they still can be brought into this and deemed to be a beneficial owner of, or have substantial control based upon their percentages. So there are some exemptions in all these. I mean, for example, minors don't have to be disclosed, provided that their parent or legal guardian is actually being disclosed as part of this. Custodians in certain circumstances, creditors, There are different, different areas like that where it is possible that someone can avoid being listed. But again, those are the types of circumstances that have to be analyzed on an individual basis for this. Last definition I wanted to jump into is company applicant. So this only applies for entities that have been formed this year or going forward. But for any entity that's a newly created entity, you have to disclose up to 2 individuals who qualify as the company applicant, and that means it's the individual who filed the paperwork with the Secretary of State or other agency for the actual creation of the entity. That's one of them. There's the two categories. There's the direct filer, and then the other is the individual who directed or controlled the filing process. So, for example, I oftentimes file paperwork with the Secretary of State of various states to form an entity for clients. In those circumstances, I am the direct filer and will be the company applicant for all of those entities. However, I am doing that at the direction of some executive, some founder within the entity that's being created. That individual would be listed as the other one, as the person who directed or controlled the filing of the document. If one of you went on and filed an entity for yourself to create create an entity with your Secretary of State, many Secretaries of State allow you to do that online. Again, I can't advise people to be their own attorneys in those, because I think that there are certainly things that can and should be added into those documents that aren't necessarily going to go into them if you are simply kind of filling in a few line items on the Secretary of State's website. But if you were to take that route in forming it, and you're forming it for yourself, you're not being directed to do that by someone else, then your entity would only have a single company applicant, and it would be you in those circumstances. So, is there any questions anyone wants to hit about the definitions before I move on? Okay, moving on. So, one part of this is beneficial for everyone, and that's that as opposed to most states have an annual filing requirement associated with having an entity. There is no annual reporting requirement for the Corporate Transparency Act. So you make your initial filing with FinCEN, and if no information changes, then it's literally a one-time filing obligation. If any of the filed information does change, for example, the entity relocates, moves to another address, one of the named beneficial owners moves and has a new address, any of those types of circumstances will trigger the obligation to file an updated report with FinCEN, and that must be filed within 30 days after the change occurs. So, it's important, if you have an entity which has numerous beneficial owners as part of it, that everyone be alerted to the necessity of keeping whoever's handling this for the entity informed if there is any type of change to their information. So if you were to make a filing and you're discovering that there's an error that was made, the obligation is to file the corrected information within 30 days of becoming aware of the error. There is no penalty for an inaccurate report if it's corrected within 90 days of the initial filing. So if there was somehow a mistake in your initial filing for it, then you do have a grace period associated with that as well. And the last point here I kind of touched on a bit earlier, but effectively everyone has to file at the start unless they're meeting one of those exemptions. But if an entity subsequently becomes eligible for an exemption, then it must update the report and indicate that. Again, one of the examples I think will probably happen a lot going forward is the entities that are becoming a tax exempt 501c organization. So, they're in all likelihood going to have to file at the beginning, and then, when they are approved for that, they would file an updated, CTA report to show that they're exempt. Obviously, many business owners are hoping that they create their business and it grows and it's going to turn into a large operating entity as well at some point. And if they do reach a point that they meet, all three of those requirements, then they would file an updated report at that point and show that they're no longer required to continue to comply. Again, provided they continue to meet that exemption. So this is something, everybody always asks about. What if they don't comply? What happens if, if I just don't do this? There's a civil component to the penalties, and then there's possible criminal penalties. And there's some erroneous information, a lot of it that you'll see online by groups that have tried to kind of quickly summarize this. But the civil penalty component it's currently $591 per day. It was originally passed as $500, but it's indexed to inflation. In all likelihood will just continue to increase over time. But that's $591 per day per violation, ongoing for as long as the violation continues. So if you just fail to file and don't ever address it, this liability is just going to continue to grow. Many of the reports about the penalties talk about, it's, they would say, $500 per day up to a maximum of $10,000. Combining the concepts of the civil penalty and the criminal penalty. On the criminal side of this, the potential penalties up to 2 years in prison, and then a criminal fine of up to $10,000. So, but the civil penalty would continue to potentially grow. Potential violations arise, if you willfully fail to file. You don't submit your report. You file false beneficial ownership information, or you willfully fail to correct or update information if it's changed, and do your updated report. All of these are potential violations. So let's say you don't make your initial filing. That's one violation. If something has happened that some of that information has changed and there should have been an updated report filed, that's another violation. So this can stack up and add up and become something obviously that's very significant. As we'll get into at the end of this, it's a pretty small lift to actually be compliant, and certainly the costs associated with that are a fraction of what the potential penalties are. So it's important to know also that the people who are actually filing this. So if you're filing on behalf of your entity yourself, and you're gathering the information, and you're wanting to submit this to FinCEN, then you have liabilities associated with handling that information, and that also can include a fine of up to $250,000, and again that $591 per day civil penalty. So they're very substantial fines. I mean, my personal view, and again, this is I don't have a concrete basis for this, but I obviously think that it's going to be difficult for this to be enforced against everyone who doesn't file. However, what I tell all of my clients, and what I tell anybody who asks me about it, is that how can anyone afford to be the test case for this? It's again, when you're talking about this type of potential liability, it's first of all, everyone should comply with the law always anyway. But I do know there are people who don't for various reasons. But when you can fairly cost effectively eliminate this potential liability, it's obviously in my view the wise thing to do. Who has these liabilities? So the individuals as well as the entities can be held liable under the Corporate Transparency Act. It is the responsibility of the entity to identify and report the information regarding its beneficial owners and company applicants. And as part of this, there's a certification process that the entity does that the information is true, correct, and complete. Obviously, you can't put an entity into prison. So as part of this, individuals on, officers of businesses and things that are the ones who would be hit with with penalties as well. And they can be held liable if they cause the failure to file, if they cause the failure to update the information that's required, or if there's just a senior officer at the entity at the time of the failure. So, all of them have the possibility of liability as well. Accordingly, the enforcement action can be brought against any individual who willfully fails to provide required information. So let's say you're one individual who would be deemed a beneficial owner of a company that you don't control. You have an ownership position in it or whatever, and you're a director of the business, and they believe that you should be named as one of their beneficial owners. If you say, no, I'm not giving that information to you, I don't want to be named in this, you have potential liability as well for willfully failing to provide the required information. So it's, again, the entire act is set up to be very broad reaching and to capture, as many people as possible. So it's, just something to not take lightly. A lot of people ask also who has access to the information. They're concerned about, in particular with their personal information, who can go on and see where they live or what their, what their driver's license information is or the copy of their passport and things. It's not open to the general public. It's a secure platform that the government has created. And it is a non-public database, but the information is accessible by federal, state, local, and tribal officials, be these law enforcement agencies or governmental agencies. Financial institutions such as banks have the ability of getting access to it with the consent of the reporting company. So it's my belief that because of this, there will be a change with banks over time, where there's probably going to be a requirement that as part of opening any new bank account for an entity, that you have to agree that they would have the ability of accessing this information as well. So I can see I can see that coming into fruition pretty easily. The financial institutions regulators and those who supervise the institution will also have access to it through that. Certain foreign officials and agencies can gain access to it as well, but they have to submit a specific request through a U.S. federal governmental agency, and it can't just be for no reason. It has to be related to either national security issue, intelligence issue, law enforcement, things such as that. So the effort is being made by the government to protect it and treat it in the same manner in which and I've put the quote down here that essentially the way that the federal government protects non-classified yet sensitive information systems at the highest security levels. So probably no system is foolproof, but their intent is to keep this out of the public eyes. So additional considerations for all of you to keep in mind. Many of you may have received an unsolicited email from groups that would say, have information about this and say it's coming up or that you need to report, and click here to do so. There is significant concern in the legal community about unscrupulous service providers, people who are effectively using this act as a means of identity theft. Because again, you have to submit copies of your personal ID, date of birth, name, et cetera, et cetera, et cetera. So there's risks associated with transmitting that to unknown entities. So be aware of that. In addition, because this is a new obligation, many existing entities may not have structures in place for their operative agreements, shareholders agreements for corporation, operating agreements for LLCs, for example, things like that address what needs to happen. So in many of these cases, amendments need to be done to the documents, or for new entities when they're being formed, provisions that put in place in the documents that clarify the process for them. Who specifically is going to have the obligation within an entity of monitoring this, of making the filings, gathering the information and making the filings with FinCEN. For an operating agreement, I'm including provisions for all of my clients stating that by becoming a member of the LLC, by acquiring, equity in that, they are agreeing to provide all of this required information on a timely basis. So again, trying to one, alert people of the obligations, but two, create that contractual obligation where an entity, if it needs to, can point to that to enforce the obligation upon its various beneficial owners. Similarly, the same consideration arises for employment agreements. If someone's coming in, because again, even if someone doesn't own any interest in the business, they don't have any securities that they have, depending upon what their role is in the company, they can still be deemed a beneficial owner. So all of these types of considerations need to be brought into place and documented as part of the contracts. Similarly, in transactional agreements, if you're acquiring a new business, or someone who's a company is selling a security in its business to someone, there should be an obligation within those documents. Either representations from, if you're buying a business, you want a representation that the filings have been made and that they're truthful and such to the point of the transaction closing. For a securities purchase agreement, if you're an entity selling a security to someone, you want them to agree to provide you the required information, now and on an ongoing basis if anything changes. So all these types of items need to be considered for your corporate documentation, either your operative documents or your transactional documents. Remember that there's very, very broad interpretation of many of these terms. What is substantial influence? It's just broad reaching. It's meant to capture as many people and as many entities as possible. So, my recommendation is that you err on the side of disclosure in order to avoid these potential penalties. It's been stated from FinCEN that they don't necessarily believe that every director of a company is actually, having substantial control. And they don't necessarily believe that every director would need to be disclosed. But they go on to state that analyzing which directors do is a fact-specific inquiry, and there's really not a lot of guidance in terms of what to look at specifically for that inquiry. So, it's the safest way to go in that circumstance is to disclose all of them. It's if someone's going to be a director of a company and be involved in it, then they in my view, again, they should be disclosed, and you can eliminate the possibility that the government comes back and says, oh, by the way, you forgot to disclose that Lorna was a director on, a member of the board of directors here, and we believe, despite what you say, we believe that she should indeed have been disclosed. So that's the presentation. So I'm my contact information is here. Copies of this can be received by contacting Janine. I'll move out of the way here so you can see her full email address there for a moment as well. But I'm still happy to answer more questions if anybody else has other questions. Certainly happy to assist any of you with this process. on a going forward basis. And I do encourage you to take this seriously. I do encourage you to file. I encourage you to tell friends of yours, colleagues, family members who have, any entities about it as well. I had numerous entities of my own that for various reasons, one that, for example, owned a piece of property and, things like that. And again, even if the odds of being ever caught, by the government on this are slim, one, I would certainly always comply anyway with the regulations. But two, the just being compliant and having that assurance that there's not that potential ongoing liability is I believe worth a significant amount to people. So that's the presentation. So I'll
Two
stop talking
questions.
for a minute. Yes, go ahead.
Okay, firstly, not-for-profit entities, are they exempt? I didn't catch you.
They can be. They can be. As I was mentioning, that is one of the areas that if they have received, and again, it's there's a couple tiers to it, but they have to have received their notice of being formally their formal paperwork from the IRS that they are indeed tax exempt. They have to have received that within before the deadline to file is, which is why I was saying for any newly formed entity, even if it's formed for the purpose of being a tax exempt entity, the odds are high, I believe, that they won't have everything approved prior to their filing deadline. So they would need to file as a reporting entity, and then if and when they meet all the requirements, they would update their report to show that they are at that point exempt. It's also if even if an entity does have their 501c designation, if something happens and they fall out of compliance and they lose that, then that can trigger the obligation of filing at that point.
A follow-up question for that. Any not-for-profit religious organizations such as mosques or churches, they do not have any reporting requirements to the federal IRS. Are they still required to report under this act, mosques and churches?
It not again,
No,
not necessarily.
they don't have to file 990 Form 990 with the IRS. I think you know that, right? A religious
I mean,
organization.
I'm not the tax guy on the call, but
I know.
but I am aware that a church doesn't file tax returns. Yes.
Correct. So will they be subject to
No, I mean, again, there are nuances to all of the exemptions. There are 23 different exemptions, to go through. Certainly, kind of offline, I'm happy to explore specific circumstances and things with you, to have kind of a further, more detailed conversation about these things.
My second question, has FinCEN come up with a standard form for reporting this under this act? Is a standard form for that?
It's not necessarily a form that you're filling out and mailing to them. The process of complying can be done through FinCEN's website. But again, there's a layer of legal analysis with all of this. That it's just as if even though it's possible for people to file their own tax return, it's oftentimes not advisable for them to do that. So. In my view, in these circumstances, again, it's best to let someone who's doing, many of these on a regular basis to handle it. For my firm's own purposes, with this, we charge a flat fee of $550 for handling the filings for an entity. I have stated that, as part of this for clients coming in through A&A that, I would discount that and give $100 off on the filing fee for it. So, happy to do that, for anyone who's coming in, if you're contacting, just to remind me that you learned about this and saw the presentation here, and I'm happy to give that discount to you.
Jim, my last question. FinCEN has a form for reporting foreign bank accounts. I'm sure you're aware of that.
Right.
So why don't we come with a form for reporting under this act? I mean, it's going to simplify the process, won't it?
I'm not here to argue that the act is perfect and that it's the most efficient way of doing any of this, but
For ease of compliance, they could come up with a form, just like for foreign banks reporting.
Again, I'm not the person who
I understand that. Yeah. Just a comment. Okay.
I get it. I get it. No, I mean, I am part of a group of attorneys who communicate, in the aggregate with FinCEN regarding, areas that we believe need clarification and
Right.
questions that need to be addressed and things like that. So, and it is something that they, I think there's recognition that there's, continued clarity in various areas that needs to happen.
Right.
And it probably will continue to happen over time.
Thank you.
Sure.
Do we have any other questions? Seems to me that it's a fairly complex situation. So
Just call Jim.
that's my comment. Just call Jim.
Yeah, it's again, in some circumstances it's fairly straightforward. In other circumstances it gets hairier. So, which is
Mhm.
why, again, I feel that, it's important to, seek counsel for this.
Yep.
So again, well, thank you very much for the opportunity to do this. I do appreciate it. I hope that it was this was informative for people and helpful. And again, I'm happy to connect directly with any of you if you have the need for services or have additional questions.
Thanks, Jim.
Thank you, Jim.
Appreciate it.
Sure.
Really-
Thank you, Jim.
Great. Thank you, everybody.
Thank you.
Yep.